Welcome to week 12, only 3 more weeks to go. I hope everyone's getting through the social distancing and stay at home environment well. There seems to be no lack of online resources for both the students and the faculty. So there's lots of information, and hopefully you've been getting email feeds from the law school about what's going on, as well as some new grading options that we'll talk about later toward the end of the semester. And as always, of course, you can always reach me by email and by text. Okay, so this week, at this point in the semester, we've talked about the basic building blocks of a corporation. Number one, formation. How does a legal creature known as a corporation come into existence? What laws govern its existence? What responsibility does it have to its shareholders and to others? Number two, capital. There are different ways that capital can be structured in terms of equity, as we know, common, preferred, or a combination of those, and debt, which can be secured or unsecured. And remember, the secured versions are called debentures, the unsecured versions are called promissory notes. Number three, we've talked a lot about shareholders, their right to vote, the most fundamental right they have, their ability to elect the directors and to vote on other issues, and their right to receive information, which of course is another major right that shareholders receive. In this regard, we've talked a lot about internal corporate governance mechanisms, such as the Articles of Incorporation and the Code of Regulations. These are the fundamental corporate governance documents. Fourth, we've talked about management, and starting at the top with the directors, those individuals who oversee the entire corporation and who are charged with making major decisions affecting the shareholders and perhaps even other constituencies. They hire all the officers, including the CEO, and decide if and when to issue securities of any kind, as well as to issue distributions of profit to the shareholders, that is, dividends. Fifth, we've talked about markets. And we've discussed in some detail the nature of public markets for securities, and specifically how they are regulated by the SEC and state securities regulators. In these markets, the shares of a publicly traded corporation are available for purchase by anyone who can ante up the money. So what does this mean for a corporation? Well, we've discussed the primary motivation for a company to, quote, go public, end quote. That is, to be able to access public capital markets, to be able to raise money by selling little pieces of itself to the public. This technically puts the company up for sale a share at a time. The next topic that we're going to talk about this week involves the dynamic among and between all of these facets of the corporation in the context of an attempt by one corporation, typically through its directors and officers, to gain control or to purchase another corporation against the will of that corporation. This is what we refer to as a takeover. This is to be contrasted to a transaction in which corporations consensually negotiate an acquisition or a combination or a merger of their respective companies. We'll talk about that mechanism later in the semester. Just to break it down to its most basic terms, corporations and the property they own can be purchased in one of two ways. Number one, the target management enter into a contract with the acquirer to purchase all or substantially all of the target's assets, its property, machinery, equipment, inventory, intellectual property, customer base, anything else that they have. Once the target sells its assets, it no longer owns those assets, but receives cash, which it then uses in the continued operation of a business, assuming it didn't sell all the assets, or it distributes the cash to the shareholders as a dividend or in liquidation of the company. The second way a corporation can be purchased is for the target shareholders to sell their shares directly to the acquirer for whatever price they agree. Once the shareholders sell their shares to the acquirer becomes the shareholder of the target. It is this scenario that we're primarily discussing this week. One of the primary tensions in this area is between management, that is, the directors and officers of the corporation, on the one hand, who not only control the strategic and operational direction of the corporation, but who are also typically shareholders and perhaps employees of the corporation. On the other hand are the shareholders, which also may include the contingency who seeks to take ownership and control of the corporation. So we've got this tension between shareholders who may want to entertain a buyout offer and a management who may oppose a buyout offer for a number of reasons, some of which are certainly legitimate, others may be suspect. Given the natural tendency for most people to primarily look out for number one, when is management looking out for itself instead of the corporation's stockholders, to whom management, of course, has a fiduciary duty, as we've discussed in this class? We talked about the market dynamics surrounding a company, which is a possible target of a third party's offer. What happens to the market value of a publicly traded company that is, quote, in play, end quote? Its shares tend to go up in value. The idea is that if something is desired in the marketplace, the price will be bid up. If the goal of a corporation is to increase shareholder value over time, shouldn't management always be in favor of an acquisition offer that promises to deliver the increased value to shareholders? Should management also look out for the interests of, quote, other constituencies, end quote, the community, the workforce, suppliers, customers? As we've seen from the prior cases involving the business judgment rule and shareholder derivative actions, shareholders and management are not always in agreement. So let's talk a little bit about terminology in this area. The party or the entity or group initiating a move to gain control is referred to as the acquirer. And according to this text, it's the aggressor, although I rarely have seen that term used with any frequency. The entity that is the acquirer is seeking to acquire, the company that the acquirer is seeking to acquire is typically referred to as the target. The various corporate structuring strategies used by corporations to fend off an acquirer's overtures are generically referred to as defensive measures or defensive strategies. They're sometimes not given a particular tag but have that same effect. We'll talk about that, those particular defensive measures on Thursday. Tonight, we're going to look at legislation aimed at regulating takeovers and some of the public policies behind this type of legislation. Thursday, we'll look at corporate governance, structural mechanisms that corporations sometimes adopt in order to fend off an unwanted takeover attempt. Let's talk a little bit about the beginning of the takeover movement. Historically, the wide dispersion of shareholders basically ensured the self-perpetuation of management. The text, I think, refers to this as, quote, autonomous management, end quote. Why is that the case? Quite simply, the more shareholders, the more widely dispersed, especially in the pre-internet world, the harder it is for any one voice to be heard. It's harder for shareholders to combine forces and to combine their voting power in the corporate context. With technical innovation and communication came the growth in capital markets as people were able to exert more power in terms of determining the course of the corporation. The rise of institutional shareholders, pension funds, mutual funds, banks, who accumulate large positions in a corporation's shares on behalf of a large number of beneficial owners, are motivated to have their voices heard. We've talked before about these record owners who may own shares for many, many, many beneficial owners. Those institutional holders of shares are motivated to have their voice heard on behalf of those for whom they hold the shares. Remember, the record owner has a certain fiduciary duty to beneficial owners of those shares. What we're talking about here is effecting a fundamental change in control and management of a corporation. The original change of control mechanism was the proxy fight. What are we talking about here? Well, we know what proxies are. We've talked about them from a state corporation law standpoint. This is where an individual gives his vote to another person to vote on that original person's behalf. And with proxy fights, we're talking about shareholders collecting essentially the right to vote other people's shares in the interest of combining their voting bloc to a point where they can effect significant change in corporate governance. So what's the most basic way to change management? Of course, that is by shareholders exercising their most basic right, the right to vote. Insurgent shareholder groups versus management. Let's talk about that. If you're a shareholder and you're unhappy about how the company is being run, you can organize your fellow shareholders to vote the directors out of office. You'd be considered the insurgent group. You'd be soliciting proxies from other people who may not be as motivated as you are to organize this effort, but you're motivated, and once you explain it to them, they give you their vote. We've already talked about proxies and proxy solicitation. This is essentially a competition between those who want to effect change and others who perhaps like things just the way they are. Both sides can solicit proxies in a particular contest via the mechanisms that we've discussed previously, and provided that the requisite disclosure is made to the person whose proxy you're seeking. As we learned before, soliciting proxies is very much akin to running a political campaign. Getting access to shareholder lists, like voter rolls, preparation of proxies, solicitation of shareholders. There are even professional proxy solicitors. If you are able to look at the link for Jorgensen, Jorgensen is a company that does nothing but engage with companies to organize proxy solicitation campaigns in the context of these dynamic transactions we're talking about this week. That is, potential fundamental change of control transactions. A proxy solicitor like Jorgensen is like a campaign manager, like a professional campaign manager who specializes in how to get access to voters, how to communicate with voters, how to convince them to give their proxy to whomever is hiring the proxy solicitor. Costs of proxy fights are significant, and each party foots its own bill. If management loses, the corporation gets saddled with the costs of the process. Question, is it legal for directors to charge costs of fighting a proxy battle to the corporation? What if the goal of fighting the proposal is to protect the corporation in a legitimate way? On the other hand, what if the main purpose in objecting to an insurgent's issue is management's desire to retain their jobs? Should insurgents' expenses be paid, even if they lose, but if their campaign leads to beneficial changes later? Let's say, for example, the insurgents seek to amend the Articles of Incorporation to state, as part of the corporation's purpose, is to encourage environmentally sound business practices. The measure is defeated, but the company later, after continuing unofficial campaigning, adopts this provision. Types of relatively common proxy fights in the takeover area include proposals to adopt a recapitalization of the corporation, perhaps to make it easier for a would-be acquirer to purchase shares of the target, thereby giving shareholders the opportunity to perhaps enjoy a premium in a takeover transaction over what they would get in the market otherwise. Other common proxy fights include the removal of anti-takeover defenses of the type that we're going to look at on Thursday, again, with the goal of allowing shareholders to exit their investment, liquidate their investment at the best possible price. As we'll see, the proxy rules also require disclosure of who is financing a particular proxy contest. All-out proxy fights are less common these days as change of control devices, but they still take place. They have been surpassed in large part and in frequency by the cash tender offer. This is a more direct way to effect change at the board level, buy enough shares to vote the directors out of office. The first of the four-digit code that I'll ask you to report at tonight's session is the number 8. The first code is the number 8. So let's talk a little bit about tender offers. In a tender offer, the acquirer simply offers something of value for the issued and outstanding shares of the target, something worth more than the current trading price of the shares. An exchange of the acquirer's shares for target shares may be one way. This typically requires a 33 Act registration of the acquirer's shares to be offered to the target shareholders. From an acquirer perspective, this has the advantage of not requiring the acquirer to come up with cash to buy the shares of the target. The other way is a cash tender offer, which is more direct. Cash in the amount greater than the current trading price of the target shares is offered. Our text points out that in virtually every cash tender offer, the offering price represents a substantial premium over the target's current trading price. And they give the example of LinkedIn that was acquired for over 50% over its trading price. That was the premium. These offers can be made through a newspaper. They can be made through a direct mailing. They can also be done through a proxy solicitation process. The advantage of a cash tender offer is that rather than having to decide the merits of competing proxy proposals or to be required to determine the value of the offering company to get a sense of whether its shares are worth more or less than the target shares, the investor simply makes a financial decision to sell the shares or to hold the shares. In the early days of cash tender offers, the offerer wanted to make the tender offer and receive acceptances as soon as possible. And this was to avoid a chance for the market to bid up the price of the shares. Our text talks a little bit about on 770 this example of the Saturday night special where an offer would be made on Friday saying you have to tender your shares by Monday. And of course, that's very little time for a investor to be able to make that analysis, make a rational business decision. It's also a very short amount of time for target company management to digest the offer, figure out whether it might in fact be in the best interest of the corporation's shareholders, and to permit it to go forward. Another player that has an influence on this dynamic are the speculative investors called arbitrageurs. This is from the Latin word meaning to judge. Those who speculate on the price run-up, anticipating and resulting from a tender offer announcement. This has the effect of creating a certain amount of artificial market activity by those who will buy shares, wait for the price to go up a few dollars, sell it immediately, really without having any intention of being a long-term shareholder of the corporation. In the 1960s, a large number of takeovers occurred unannounced, and this created difficulties for management, which of course have a fiduciary duty to the shareholders, and also difficulties for stockholders who are forced to make crucial decisions with very little preparation. Enter the Williams Act in 1968. The Williams Act is, in fact, a set of amendments to sections 13 and 14 of the 34 Act, the Exchange Act. The rules basically govern tender offers involving publicly traded corporations, all of which are intended to minimize the element of surprise to management and shareholders, to give management a better chance to react to and digest tender offers, and to give shareholders more complete information for making what is essentially a financial business decision of whether or not to sell. But summarizing the main goals and results of the Williams Act. Number one, bidders are required to disclose all details of their tender offer in their filings with the SEC and with the target company. The filing must include the terms of the offer, cash source, plans for the company takeover, etc. We'll talk about that in a minute. The Act also provides time constraints that stipulate the minimum period of time the offer must remain open and the number of days after the offering in which shareholders have the right to change their minds. Filing and public disclosures with the SEC are also required of anyone who acquires more than 5% of the outstanding shares of any class of a corporation subject to federal registration requirements. Copies of these disclosures must be sent to each national securities exchange where the securities are traded. Think NASDAQ, New York Stock Exchange, etc., thereby making the information available to shareholders, security analysts, and the public generally. And this is, of course, consistent with the efficient capital market hypothesis we've been discussing, which posits that if all information is made available to all potential investors at the same time, the deciding factor on whether a shareholder buys or sells shares will be the fundamental health of the business itself. The law also imposes miscellaneous substantive restrictions on the mechanics of a cash tender offer and imposes a broad prohibition against the use of false, misleading, or incomplete statements in connection with a tender offer. And finally, the Williams Act gives the SEC the authority to institute enforcement lawsuits to enforce its provisions. Since I know you don't have access to the hyperlinks that are on the screen, I'll just speak to a number of the rules from Regulations 14D and 14E that I want you to keep in mind. 14D is the current regulatory set of rules governing tender offers involving publicly traded companies. Remember, in week 4, we talked about Regulation 14A briefly when we talked about the proxy solicitation process involving publicly traded companies. Now we're revisiting Regulation 14A to discuss the specific proxy rules involving tender offers. So which ones are important? Let's look at 14D2, commencement of a tender offer. If you look at that rule, you'll see that a proxy offer in a tender offer context is, a tender offer is considered to be commenced on the day, actually 12:01 a.m., on the day that the bidder has first published, sent, or given the means to tender to security holders. Now, you'll notice it doesn't say the day they've purchased the shares. It's the day they've made information available to the target shareholders as to how they can tender their shares for payment. The second rule I want to look at is 14D3, and I alluded to this a few minutes ago. This is the rule that requires that if a acquirer is tendering to buy at least 5% of a class of the target's securities, then they have to file a tender offer statement. It's called Schedule TO with the SEC and to provide copies to management of the target company. This is a way to, again, ensure that the information makes its way into the SEC disclosure system. 14D6 is the section of the rule under Regulation 14D that talks about exactly what information must be provided to target shareholders, and I alluded to this a few minutes ago. The most basic information. You have to list the identity of the entity who's tendering, who's offering to buy the shares. Number two, you have to disclose the amount and class of securities being offered. Exactly how many are you tendering for? You have to disclose the type and amount of consideration being offered. Is it cash or is it securities? If it's securities, then as we know, there are a number of bells and whistles that could be attached to that equity. Is it voting or not voting? Is it pay a dividend or doesn't pay a dividend? Is it convertible into another kind of shares? Does it have any kind of a liquidation preference, etc.? And then number four, you're required to indicate in your filing and your communication when the tender offer expires, how long it's open for, and what are the procedures if it's going to be extended. The last rule I want to point out is 14D10, which has came up historically in a lot of these situations where acquirers would make one offer to a number of shareholders to get them to tender and another offer to another set of shareholders. 14D10 says that all shareholders must be treated the same way in a tender offer. Everybody who has common shares for which a tender is being made must be paid the same consideration, have the same timing involved, receive the same disclosures. So Regulation 14D essentially talks about the mechanics of setting up a tender offer under the rules. 14E, on the other hand, focuses more on, I will call them the bad boy provisions, the shall nots of the tender offer world. The first one I want to look at is Rule 14E1, unlawful tender offer practices. So after you've launched your tender offer, made all the filings, these are things you can't do without running afoul of the law. Number one, you have to hold the offer open for at least 20 days. This is 20 days from the date the tender offer is first published or sent to security holders. 14E3 is a specialized insider trading rule. Think about last week's problem. This is trading on information that's not public and that's material that has been learned of or gleaned from a tender offer transaction. There may be conversations that take place between the offering company and the target company and its shareholders. There may be conversations between the acquiring company and the target company officers and directors. If you learn of inside information in that process and trade on it, it's a violation of Rule 14E3. This implements, to a certain extent, the 10b-5 anti-fraud prohibitions we've talked about before. The next rule I want to mention, the last rule I want to mention under 14E3 is 14E8. 14E8 is a rule that basically says that it's illegal for a acquiring company to have make certain sorts of false statements in connection with a tender offer. Specifically, because timing is so important, as we see under these rules, Rule 14E8 basically says it is considered a fraudulent, deceptive, or manipulative act or practice. Does that sound familiar? That's 10b-5 language. Basically, to basically make statements about a potential tender offer without the intention of commencing the offer within a reasonable time. That is, let's say someone decides they want to gin up the market and get the stock price to go up. They may make some false or misleading statements about whether or when a tender offer is in fact going to be commenced. This is treated as market manipulation. So this is a specific rule about making false statements about the commencement of a tender offer. Let's talk a little bit about leveraged buyouts. As you'll see as we get into this, it impacts this whole dynamic of takeover transactions. We talked briefly about these types of transactions when we talked about debt financing. Remember, leveraged buyouts are the kind of the classic bootstrap transaction. The acquirer incurs debt to achieve the buyout, and the debt is secured by the target's assets. The target assumes this debt after the acquisition. The question is, can the target shoulder this debt? What if the acquirer is borrowing too much money such that post-acquisition the company is absolutely in the red, even though the fact that interest on the new debt is deductible by the target corporation? So the analysis focuses typically on something we call EBIT. It's an acronym, EBIT. What's EBIT? Well, because the taxes are generally wiped out by the deduction for interest on the borrowed debt, earnings before interest and taxes, EBIT, is a more accurate measurement of how the business is doing. So again, once a majority of shares are obtained, what do you do with the remainder of the shares? Well, there are a number of ways that an acquirer can come up with money to effect a leveraged buyout. Where does the money come from? Well, there are a couple of ways. There can be bank debt coming from a lender to the new company, the acquiring company. Basically, bank debt borrowed against the target assets, and it's leveraged, motivated generally by fees charged to the borrower on top of interest and the security of collateral. That's the bank's buy-in proposition. Money to finance the acquisition can also be in the way of bonds, corporate debt obligations, secured, maybe high yield to entice lenders, since they typically are second in line behind banks, and they are typically motivated by high yields. In earlier times, these were called junk bonds. They paid a high rate of interest, but were subordinated to senior debt, such that in the event of a liquidation, whether they would be repaid or not was risky, and therefore they offered a higher interest rate. Another way to finance the buyout is with equity. The acquiring company, hoping they'll succeed, since the basic rationale behind the acquisition was to improve the existing management's performance in the first place, may offer equity in the acquiring company to new investors, or a combination of all of the above is not atypical in a buyout transaction. An additional consideration made by an acquirer in determining whether it's going to acquire a company or whether it makes sense to acquire the company is whether they can sell off the business in bits and pieces after they've acquired it. The idea being, if we can sell off the various parts for more than we invested, or more than the debt we incurred, we come out ahead. These are very generically referred to as bust-up transactions, in which the target is acquired and then sold off in pieces. For instance, equipment may be sold to one buyer, real estate to another buyer, intellectual property to another buyer, accounts receivable to another buyer, etc. This type of rationale forms the basis for management typically to oppose these acquisitions because it impacts workforce, who are typically laid off permanently. It affects the community if there are vendors, suppliers, restaurants, banks that supply the workers' needs. If there are property taxes, payroll taxes that are typically paid, these sort of bust up transactions can have a fairly significant impact on a whole community surrounding the target company. And as I said before, is often one of the rationale put forth by management in opposing one of these takeover transactions. I'm going to talk a little bit about litigation involving takeover transactions. Our authors point out that more than 95% of takeovers involving value of $100 million or more experienced a shareholder lawsuit. And as we said before, there are a number of reasons there might be a shareholder lawsuit. There could be the shareholders' desire to liquidate their investment, which might be opposed by current management. There may be litigation because the pricing appears to be unfair to the shareholders, and the shareholders want to have a say in how this is consummated. 85% of settled cases in the survey, our authors point out, resulted in no money, just an order that the corporation and the acquirer make additional greater disclosure concerning the proposed transaction. Full disclosure is paramount in these types of deals. The next case illustrates that reality in the context of litigation associated with Zillow's acquisition of Trulia in 2015. So let's talk about the Trulia stockholder litigation. This is a Delaware Chancery Court case from 2016. Trulia and Zillow, as you may know, are real estate websites that allow consumers to go in and shop for real estate and price them and see where they're located, et cetera, et cetera. Several Trulia shareholders accused the directors of breaching their fiduciary duty by under-disclosing the terms of a stock-for-stock merger. Now, as you know by now, stock-for-stock mergers involve trading one company's stock for another company's stock, and obviously you need to know and understand a lot about the other company to know whether the exchange of the shares is going to be equal. Sometimes in a stock-for-stock exchange, it is a one-for-one exchange. Sometimes it's a two-for-one exchange, it's some other proportion exchange, so it's not always equal. And that exchange ratio, as we call it, is a function of the market value and perhaps other values of the companies. So there's an opportunity for management to make representations to stockholders about whether they think they should accept this type of exchange, and the shareholders from Trulia took exception to that. All of the parties eventually entered into a, quote, disclosure settlement, quote, pursuant to which the purported class plaintiffs dropped their claims in exchange for more disclosure, which is really what they wanted all along. Other shareholders challenged that settlement. This court refused to enforce the settlement on the grounds that the additional disclosure by Trulia was in fact worthless. In other words, the settlement, the disclosure settlement that some of the named plaintiffs had agreed to enter into was really not worth the settlement value that it had. And the court said in that case, quote, the court will continue to be increasingly vigilant in applying its independent judgment to its case-by-case assessment of the reasonableness of the, quote, give and, quote, get of such settlements. We shouldn't be surprised that these types of cases get the attention of state court judges, since corporation law is first and foremost state law, and corporations are creatures of state law. I want to shift gears a little bit now and talk about the area of state legislation regulating corporate takeovers. Oh, by the way, code number 2 of the 4-character code you need to give me at the end of this is the number 4. code number 2 is the number 4. Why are there legislative enactments that regulate takeovers? And that's what we're talking about here. State law, statutory law that impacts the ability of a acquiring company to make a tender offer on a corporation that's been formed under that state's corporation laws. So think of it this way. Corporations are, quote, corporate citizens, end quote, citizens that pay taxes, engage in commerce, create jobs, consume goods and services, and in many ways are the backbone of the community. For those reasons, the government generally has a vested interest in keeping businesses within their community, not having them acquired and then broken up, for instance. And this is why state legislators in many states have enacted statutes that can be used by target companies to ward off or at least slow down an unwanted takeover attempt. Remember, the basic laws addressing the formation, structure, and governance of corporations, whether private, closely held, or public, are primarily state laws. And for this reason, we'll see state corporation law treated in most of the cases we'll talk about in this section. Let's talk about CTS Corporation versus Dynamics Corporation of America. This is a landmark US Supreme Court case from 1987. The facts in the case were that Indiana enacted the first state corporation law statute regulating control share acquisitions. By that I mean transactions intended to gain a majority of the shares of the corporation and therefore the power to launch a takeover. So how did this law work? It had an opt-in, opt-out provision beginning on August 1st, 1987. It applied to all Indiana corporations unless they opt out. And the way they would do that, since we're talking about not necessarily public corporations, is that they would prepare a bylaw or an article provision opting in or opting out of the law. The statute had a number of triggers. If a particular shareholder acquired a certain level of ownership, the target shareholders have a say in whether the controlling shareholder gets voting rights. There were 3 triggers, 20%, 33%, and 50%. If the other shareholders don't give voting rights to the would-be acquirer, the company can redeem the acquirer's shares. That's how this statute worked. The acquirer could force management to convene a meeting for this vote. Dynamics was the acquirer. They owned 9.6% of CTS, which was the target. 6 days after the new law went into effect, Dynamic announced a tender offer to acquire what would amount to 27% of CTS. After that, CTS voted to be governed by the new law. Dynamics then amends its complaint, apparently a complaint had been previously filed, to add Williams Act provisions and alleging that the new Indiana law violated the Commerce Clause of the US Constitution. That is the clause, of course, that says that states don't have the ability to enact legislation that would impair interstate commerce. So what was the procedural history of the case? The district court found for Dynamics the Indiana law basically being preempted by the Williams Act, and the appeals court affirmed it, relying on the preemption definition stated in Edgar versus MITE Corp., which is also a Supreme Court case construing an Illinois anti-takeover statute, basically holding for preemption also. In holding that the Illinois law in MITE Corp was preempted, the court basically wrote that the Illinois law, quote, wholly frustrates the purpose and objective of Congress in striking a balance between the investor, management, and the takeover bidder in takeover contests. It went on to say that very few tender offers could run the gauntlet that has been set up. The other argument that was decided below was, in terms of the Commerce Clause, was that essentially battles for corporate control necessarily impact interstate commerce, since shareholders of CTS live in several states, and therefore the courts below held that it also violated the Commerce Clause. A summary, court below finds that the Indiana law is preempted by the Williams Act, and also that it violates the Commerce Clause. So it comes to this court, and this court's discussion regarding preemption is rather interesting. What is this court's test for preemption? If you look at 779, the court says that, quote, absent an explicit indication by Congress of an intent to preempt state law, a state statute is only preempted where compliance with both the federal and state regulations is a physical impossibility, end quote. In other words, right out of the box, this court is suggesting that in order for preemption to exist, it has to be more explicit in the congressional mandate, and that wasn't the case in setting up the Williams Act, at least not in the language of it. This court distinguished the Edgar versus Might case from the present case. The court considers the Illinois statute in Edgar, which was different from the Indiana statute. How was it different? Well, first of all, Might is a plurality decision. And as we know, that's not necessarily binding precedent on subsequent courts. Number two, Might had a 20-day pre-commencement waiting period. It's a 50-day waiting period in Indiana. Might had an open-ended hearing provision, not so in Indiana. This essentially put management ahead of both the acquirer and the shareholders, who may want to entertain the offer sooner. And finally, the fairness of the transaction must be reviewed by the Illinois Secretary of State, not the case in Indiana, where the shareholders have the ability to decide. The Indiana Act, by allowing shareholders to approve the voting rights of the control owner, furthers shareholder protections, which of course is the stated purpose of the Williams Act, by, quote, placing investors on an equal footing with the takeover bidder. So in other words, the court sees these distinctions between the Might case and the Indiana case. I guess its biggest no preemption argument, if you will, is that if the Indiana law is found to be preempted by the Williams Act, then wouldn't almost all state anti-takeover laws also be preempted? And this would basically ameliorate many existing legitimate state defensive devices. For instance, classified boards of directors, cumulative voting, other state corporation law devices that could have the impact of impeding a takeover. The court says, quote, in our view, the possibility that the Indiana Act will delay some tender offers is insufficient to require a conclusion that the Williams Act preempts the Indiana law. The longstanding provenance of state regulation in this area suggests that if Congress had intended to preempt all state laws that delay the acquisition of voting control following a tender offer, it would have said so explicitly. Page 782. As to the discussion of the Commerce Clause, I'll get to that in a second. Code 3, for purposes of our 4-digit code that you'll send to me at the end of this session, Code 3 is the number 2. Code 3 is the number 2. So in terms of the Commerce Clause discussion that this court had, the court points out that states are empowered to regulate corporations since they are creatures of state law, and every state has enacted laws regarding corporate governance. The court says, quote, it is thus an accepted part of the business landscape in this country for states to create corporations, to prescribe their powers, and to define the rights that are acquired by purchasing their shares, end quote. Seems obvious, but the court gives us some nice, clear language, again, hearkening back to the principle in this course, which is that corporation law is first and foremost state law. The court pointed out that state laws already impose certain hurdles to acquisitions, as we said before, the concept of cumulative voting, staggered boards of directors, dissenters' rights, as we'll see later in the semester, supermajority voting provisions to approve merger transactions, and that states have a right and an interest in ensuring that investors have an effective voice in corporate affairs. Dynamics made the argument that the state of Indiana, has no legitimate interest in out-of-state shareholders, as was the case in Might. If you look at page 783, we see that proposition. So how does the court respond to these arguments? Well, the Illinois statute applied to non-resident shareholders of non-resident corporations. By contrast, the Indiana law only applies to Indiana corporations that have substantial numbers of Indiana shareholders. Basically, the holding that comes out of this case is the Williams Act does not preempt the Indiana law. Any impact on interstate commerce is outweighed by the benefit to Indiana corporations and their shareholders. And then finally, on 784, we have the courts giving us some good language saying, quote, the very commodity that is traded in the securities market is one whose characteristics are defined by state law. Victory for state corporation laws. What's the takeaway from General Dynamics to this day? It is that state anti-takeover statutes are generally valid under the Commerce Clause and are not preempted by the Williams Act. So, does Ohio have a law like this? Yes, and that's what we're going to look at next. Ohio has the Ohio Control Share Acquisition Law. Now, I know you can't see the hyperlinks in this version of the video of the PowerPoints. I'll try to get a version of this up on the website without the narrative so you can access the hyperlinks. But anyway, I'll read them or highlight them now as we go through this. The original statute in Ohio that was intended to control these types of transactions was 1701.83. This says basically, if you look at the statute, the old statute, I think it's still in the books. It was effective in 1970. That's when it was enacted. It was a sum total of 3 paragraphs. The first one's basically saying that to effect a combination or majority share acquisition, the directors of the acquiring corporation shall authorize such transaction if the articles or regulations of the acquiring corporation require that it be authorized from the shareholders, then the shareholders will approve it. And it goes on to say that if the transaction involves the issuance or transfer by the acquiring corporation of a number of its shares equal to at least 1/6, then the shareholders have to approve. It goes on and on. It doesn't give a lot of detail regarding the thresholds of what's going to be acquired or pricing. It's really quite brief. It gives the directors the right to abandon the transaction. And that's the state of law that existed up until the enactment of the more modern version of the Control Share Acquisition Statute in Ohio. That statute, which looks like it was enacted in 1997, at least in its current version, starts out with a really interesting codification of policy. And I'd like you to take a look at it at some point. Just you'll understand a lot of the reasoning behind these laws when you read it. Essentially, it is a statement. I'll call it legislative history, but quite clearly codifies the policy that the state had in mind when they passed this. It starts out by saying, existing Ohio corporate law was designed to deal with traditional methods of transfer of control of Ohio corporations. The tender offer has evolved as an alternative device to acquire control of a public corporation that has been in widespread use in the past several decades. The acquisition of significant blocks of the securities of a public company in the open market or private transactions in connection with actual or apparent efforts to acquire control has been more common in recent years and has further complicated the impact of tender offers upon a corporation and its shareholders. It goes on to say that numerous corporations have been subject to these transactions. The second section goes on to say that the accumulation of a large block of a corporation's voting shares, however they're obtained, has the ability to affect fundamental change in the corporation itself by this shifting of effective corporate control from one entity to another. And then it goes on to talk about the fact that these can cause very fundamental changes in the business and sometimes untoward results. Third paragraph says that tender offers almost always involve a change in corporate control and therefore give rise to these same basic issues concerning internal corporate affairs. Although tender offers, in theory, offer shareholders the opportunity to consider such issues in deciding whether or not to tender their shares, in practice, they do not. Tender offers are coercive in the sense that shareholders are normally concerned that a majority of their fellow shareholders will tender their shares, leaving them in a minority position with one controlling shareholder. And then finally, the statute goes on to say that it's in the best interest of the shareholders and the corporations of the state to have some more robust controls regarding this process, as I said before. And then it goes on to talk about all the different sections of the statute that are being amended by this particular statute. This brings us to the actual law, which is 1701.831. This is the statute that everybody considers to be the Ohio Control Share Acquisition Statute, 1701.832, just being some very, very important background as to how we got here. So what does 1701.831 actually say? Well, if you open it up, you'll see that there are some important words in the statute that I'd like to focus on. So control share acquisition procedures is the name of the section. And a couple of things I'd like to point out. The first is the introductory language. Unless the articles, the regulations adopted by the shareholders or regulations adopted by the directors provide that this section does not apply, then any control share acquisition of an issuing public corporation shall be made only with prior authorization of the shareholders as set forth in this section. So a lot of words. The first point is, if you don't want this to apply, you have to opt out. The presumption is that it applies. You have to opt out if you don't want this to apply. Why would you not want this to apply? Well, perhaps you don't want shareholders to have the ability to weigh in on these transactions. A couple of other things I want to point out in this first paragraph. What is the definition of a control share acquisition? Number two, what is the definition of an issuing public corporation? I'm going to set those aside. We'll come back to those in a second. 1701.831 says that any person who proposes to make a control share acquisition shall deliver an acquiring person statement to the issuing public corporation, that is the target, at the issuing public corporation's principal executive offices. The acquiring person statement shall set forth all of the following. Number one, the identity of the person. Number two, a statement that the acquiring person statement is given pursuant to this section. Number three, the number of shares of the issuing public corporation owned directly or indirectly by the acquiring company. How many shares do they own already? Number four, what is the range of voting power that the acquirer will have if the transaction is consummated as they have in mind? We'll come back to that in a second. Number five, a description in reasonable detail of the terms. These are like the things we saw in the Williams Act, regulation of 14D. and then a representation by the acquiring person together with a statement of reasonable detail of the facts on which they are based, that the proposed control share acquisition will not be contrary to law, and that the person has the ability to make the payment that they're offering. So 6 requirements. Once a person intends to make a control share acquisition as defined, which we'll get into in a minute, they have to deliver an acquiring person statement to the target corporation. Statute goes on to say that within 10 days after receipt of an acquiring person statement that complies with the division we just looked at, Division V, the directors shall call a special meeting of shareholders for the purpose of voting on the control share acquisition. Now remember, corporations are all required to have an annual meeting. We've talked before about something called a special meeting. That's a meeting of shareholders that takes place between annual meetings. And we looked earlier at the Ohio statute that provides for how you set up one of those meetings, what sort of notice you have to give, how you have to give that notice. So this statute says that assuming that the acquiring person statement complies with the statute, within 10 days of receiving that, the directors shall call a special meeting. It doesn't say the meeting has to take place within 10 days. It says that they will call the meeting within 10 days. However, Section C goes on to say that unless the parties, that is the issuing company and the acquirer, agree otherwise, that special meeting will take place within 50 days of the target company receiving the acquiring person's statement. Goes on to say that in subsection D, notice of the special meeting of shareholders will be given as promptly as is reasonably practicable by the target company called an issuing public corporation. And there is specific requirements as to what the notice to the shareholders has to say. I would submit that this has to be looked at along with the statute dealing with special meetings generally, because these modify in some respect the general notice provisions for arranging a special meeting. Statute goes on to say that the acquiring person can go ahead and make the control share acquisition if both of the following events occur. Number one, the shareholders who hold a majority of the shares vote in favor of it. Number two, the acquisition is consummated within a year following shareholder authorization. So in other words, there has to be a vote and it has to be consummated within 360 days of the approval by the shareholders. Now, I mentioned a few minutes ago, there are some important definitions that drive the meaning of 1701.831, and I want to look at some of those now. The first thing I'd like to point out is that at the beginning of chapter 1701, there is a set of definitions that apply to the entire chapter. We haven't had any occasion to look at 1701.01 yet this semester, but this is the one place you absolutely have to look at it, or else 1701.831 won't make any sense to you. So what is an, quote, issuing public corporation? It is defined in 1701.01y as a domestic corporation, that means an Ohio corporation, with 50 or more shareholders that has its principal place of business, its principal executive offices, assets having substantial value, or a substantial percentage of its assets within this state, and to which no valid close corporation agreement exists under Division H of Section 1701.591 of the Revised Code. So, a couple of things I want to point out. Issuing public corporation is a very specific definition. It's not a close corporation under 1701.591. It's not necessarily a closely held corporation in the generic sense. It isn't necessarily a corporation that's publicly traded on a stock exchange. It simply has 50 or more shareholders, has its business in Ohio, most of its assets in Ohio. So that's important to keep in mind. If on exam you start to answer the question as if it's a publicly traded company, simply because of this statement, this phrase, issuing public corporation, I'll know you didn't read the statute. Second definition I want to look at that I think is important is, what is a control share acquisition? Well, we saw the statute talking about it in terms of it triggering the requirement that the acquirer give an acquiring person statement, triggering the requirement that the target corporation tee up a special meeting, and the ability to proceed with the transaction if it's approved by a majority of the shareholders. So what exactly is a control share acquisition? If you look at 1701.01Z, you'll see control share acquisition, that's the buzzword for a takeover in Ohio. A control share acquisition means the acquisition, directly or indirectly, by any person of shares of an issuing public corporation, which we just saw the definition for, that when added to all other shares of the issuing public corporation would entitle the person, which when added to all other shares of the issuing public corporation owned by the acquirer, would entitle the acquirer to exercise voting power in any of the following ranges. A, at least 1/5, 20%, or more than 1/3 of such voting power. B, 1/3 or more, but less than a majority of voting power. C, a majority or more of voting power. So acquiring any of these levels of ownership is considered to be a control share acquisition under the statute. If you look at subsection 2 of that definition, there are some exceptions. And the statute says that the acquisition by any person of any shares of an issuing public corporation does not constitute a control share acquisition for purposes of 1701.831 if the acquisition was or is consummated in, results from, or is the consequence of any of the following. If it's prior to 1982, doesn't apply. Pursuant to a contract existing prior to 1982, doesn't apply. If the person acquires shares by bequest or inheritance, by operation of law upon the death of an individual, or by any other transfer without valuable consideration, including a gift, as long as it's not made in an effort to avoid 1701.831. Also, if the person obtains the shares pursuant to the satisfaction of a pledge or other security interest, again, not for the purpose of avoiding 1701.831, but let's say, for instance, someone borrowed money from you and they pledged their shares in the target company. They didn't pay the debt. You basically took over the collateral and owned it. That doesn't constitute a control share acquisition under the statute. And then finally, it's not a control share acquisition if the shares are acquired pursuant to a merger or a consolidation adopted by a vote of the shareholders of the issuing public corporation in compliance with a number of statutes that discuss fundamental transactions like asset purchase transactions, mergers, and other negotiated transactions. So those are important carve-outs from the definition of what constitutes a control share acquisition. The fourth code of the 4-digit code you need to send me after you listen to this video is the number 0. Code 4 is the number 0. All right, so kind of summarizing the Ohio Control Share Acquisition Law. First of all, I want you to read it. 1701.831 is what you need to read. 1701.832 is background, as I said before. 1701.83 is the original law. which has been replaced by 831. It's also important that you read 1701.01 definitions contained in Y and Z. Without those definitions, you can't really apply 831 to any particular fact problem or any analysis whatsoever. So you have to look at that. Okay. I thought we would just take a quick look at the Delaware statute on this same subject. Quite a bit simpler than ours. And that can be good and bad depending on your perspective, of course. Section 203 of the Delaware General Business Law. Business combinations with interested shareholders. Interested means someone who's already acquired shares and is interested in acquiring more. Corporations shall not engage in any business combination with an interested shareholder for a period of 3 years following the time that such stockholder becomes an interested stockholder. Elsewhere in the statutes, interested stockholder is defined as someone who has achieved levels of ownership similar to the ones we looked at in Ohio. This imposes a moratorium on any follow-on transaction with that interested party, in other words, consummation of a tender offer, unless the directors of the corporation approved either the business combination or the transaction which resulted in the stockholder becoming an interested stockholder. That is, there was a negotiated sale, perhaps, of shares that allowed that person to obtain the shares. They didn't go out into the market and just cherry pick shareholders. Also, it can be approved if, upon consummation of the transaction, which resulted in that person becoming an interested stockholder, they owned at least 85% of the voting stock of the corporation, or the business combination is approved by the board of directors and authorized by the affirmative vote of at least 66 2/3% of the outstanding voting stock. And then, of course, it goes on to say that these restrictions don't apply if the corporation's original certificate of incorporation contains a provision expressly opting out of this section, kind of like the Ohio opt-out provision. I'm not going to give you a test on this statute. I'm showing it to you so that you can be aware that there are numerous versions of this out there. They aren't necessarily uniform. Not even every state has these. But this is how Delaware has chosen to put some controls on one of these transactions. And that's really what we're talking about here, is a statutory legislative process for controlling tender offers for shares of a corporation. We've seen overall, if it's a negotiated transaction, there's not a concern. That's because the parties have had a chance to fully analyze and engaging with this particular shareholder in a past transaction. We've also seen a mechanism for slowing down the process. We've seen a mechanism for requiring shareholder approval of the process. All of these are, again, legislative enactments manifesting government policy in favor of putting some control into what are otherwise quick-moving, highly dynamic transactions involving not just the acquisition of shares, but perhaps the takeover of the corporation, perhaps the liquidation of the corporation, and the impact that that could have on tax base of the city where the corporation is located, jobs for the workforce employed by the corporation, impact on other stakeholders who may be located in the community. What we talked about today was the basics of these fundamental change of control transactions called tender offers, mainly from a legislative standpoint, ending in our discussion of the Ohio Control Share Acquisition Act, where legislatures are purposely trying to slow down tender offers for all the reasons we talked about before. In addition to, and completely separate from, the statutes out there, which, as you know, a corporation has the option to either take advantage of or not, There's another world of anti-takeover law, if you will, consisting of internal procedures enacted by a corporation in order to make an unwanted takeover more difficult. This is entirely separate from the statutes we talked about earlier today. These defensive mechanisms are generically referred to as poison pills, in that they are poison to the acquirer. They make the acquirer disincentivized to acquire the shares of the target corporation. And we'll talk about this on Thursday in detail. But I just want to make the distinction right off the bat that these are separate from the legislative solutions that we talked about today, and that they can coexist. So I hope everyone has a chance to read over the materials. It's super important, and the following week we're going to have a hypothetical which deals with both today's topic, that is the legislative control share acquisition statutes, as well as these internal corporate provisions. I will submit that the internal corporate provisions, the poison pills, are much more complicated, much more technical, and require us to really look back at and understand everything we've talked about in terms of the role of bylaws, the role of articles of incorporation, the way a corporation is capitalized, the way meetings are required to take place, and the rights of shareholders to participate in this whole process. As always, if anyone has any questions, please email me, text me, call me. I expect to have the last set of hypotheticals back to you sometime this coming weekend. In the meantime, stay safe, wash your hands, don't cough on anybody.